Now we're going to discuss the decision that the governing body makes and the next steps once that decision has been taken. As we discussed in the previous video, where a hearing has been held, the governing body has two options. The first, to uphold a decision by the head teacher to exclude the pupil, or the second, to direct reinstatement of that pupil to the school, either immediately or by a particular date. There are a number of things that have to happen after the governing body has made its decision. The first is notification. Whether or not the exclusion has been upheld, the governing body must notify certain people of their decision. These people are the parents, the head teacher, and the local authority. If the child lives in a different local authority to that of the school, both authorities must be notified. The notification must be in writing and without delay. The decision letter can often come within 2 to 3 days, but this can vary. The governing body's decision letter must include their reasons. They must be set out in a way that enables all parties to understand why the decision was made and be sufficiently detailed. The governing body must make a note on the pupil's educational record. This note must include the outcome of their consideration, along with copies of all relevant documents. If the governing body decides to reinstate the pupil and the pupil is still currently excluded, the governing body can direct reinstatement immediately. In this case, the pupil is entitled to return to school straight away. The governing body can also choose a future date and direct that the pupil should be reinstated then. Even if the pupil has already returned to school, a decision to reinstate is a reversal of the head teacher's decision to exclude. This means that it will not be noted as an exclusion on the pupil's educational record and will not count towards the rule that a pupil can be refused admission to a school if they have been excluded twice. Alternatively, the governing body may have agreed with the head teacher's decision and upheld the exclusion. Depending on the type of exclusion, there are different steps the governing body must take. For more information on the types of exclusion, please see this link here. If the governing body has upheld a fixed term exclusion, they must notify the same people as I stated before, and make a note on the pupil's educational record of the outcome of their decision. The pupil will then be reinstated at the end of the specified fixed term if this hasn't happened already. There is no right of appeal to the independent review panel for this type of exclusion. If this has happened to you and you believe that the decision was unlawful, irrational, or that it did not comply with the law generally, you may want to seek legal advice as to whether you can challenge the decision through judicial review or another appeals process. If the upheld exclusion is a permanent exclusion, there are extra requirements for the governing body to comply with. This is because the parents or guardians of the excluded people have the right to ask for the decision to be reviewed by an independent review panel. When the governing body is sending the decision letter to the parents, it should also include the following details. The fact that the exclusion is permanent. Notice that the parents have the right to appeal to the independent review panel. The details of how and where the parents should appeal if they wish to, such as where to send the appeal application, what the application should include, reasons for appeal, supporting evidence, and any relevant reference to the pupil's special educational needs. The date by which the application to appeal to the independent review panel must be made. This is 15 days from the date on which the notice is given to the parents. If the letter was hand-delivered, the notice is given on the same day. If the letter was posted first class, then the notice was given the following day. Knowing the difference is important, as you'll have different deadlines for an appeal application. The availability and role of a special educational needs expert, which will be at no extra cost to the parents and irrespective of whether or not the school considers the pupil to have special educational needs. If the parents wish for a special educational needs expert to be appointed for the independent review panel hearing, they should make this clear in their application. That the parents may, at their own expense, appoint a representative to make written or oral representations to the panel, and that they may also bring a friend to the review. That if the parents believe that the exclusion has occurred as a result of discrimination, they may make a claim under the Equality Act. If the case is related to disability, this will go to the first tier tribunal. For any other form of discrimination, it will go to the county court. The parents must be made aware that a claim must be lodged within 6 months of the alleged discrimination taking place, i.e. the date of exclusion. Relevant sources of free and impartial information that will allow the parents to make an informed decision on whether or not to appeal. Links to some of the relevant institutions and guidance can be found below under the heading Information for Appealing a Decision. Thank you for watching this short video on school exclusions. The links for all the videos mentioned can be found in the description box below.
We hope that you've enjoyed the video and you found the information that you were looking for. If not, please visit our YouTube channel and watch our other videos for more information on school exclusions.
Bye!